Good morning again, everyone. So we stop on the 13th in relation to final account. After the final account, we go on to the final certificate. So final certificate, there are two portions. The first portion is the general concept. Now this is the last section. There is final certificate in relation to the PAM 2018 provision. So it is covered under the clause 31.4. So under the 31.4, after the final account and everything are tidied up, and only after the CMGD issued, then the final certificate process is triggered. As long as the CMGD not issued, then this step is jammed up. Okay, so final certificate is linked to the end of the defects liability period and also after the issue of the CMGD. There are some consultants or the employer force the contractor to be at the project site by withholding the CMGD. That is improper. Okay, so once the final certificate is issued, authority under the contract comes to an end. The architect's authority comes to an end. That is called functus officio. The term for it is called functus officio. It's a Latin word. So you just have to remember that means the authority of the architect, named architect, ends and have no power to issue any certificate or official dealing. The word is official dealing with the project between the employer and the contractor or other parties comes to an end. Official dealing. The name architect can be there at the project site for the maintenance. For other things that may crop up. But official dealing ends. Anything from this point onward is between the employer and the contractor to get it resolved. So the employer may engage the architect or the QS to tidy up certain loose ends. Now that is another private arrangement. Officially, the service of the name architect comes to an end when the final certificate is issued. Now that is the important concept. Okay. So anything that deals with the project, the architect cannot issue any certificate. Okay. So now, what are the timeline for final certificate to be issued if there is no problem? Okay. So within 21 days for the penultimate certificate to be issued. So if there is a penultimate, then this 21 days, the clock starts. So be careful. So this penultimate certificate is the main contractor's item. Okay, it's different from the penultimate certificate to the NSCs. Okay, because if there is a penultimate to the NSCs, is the final, almost a final certificate to the NSCs. It's different. This penultimate certificate is the main contractor's item. That means it's equals to this one is a little bit confusing. Okay. So if you interpret the penultimate certificate as the NSCs, then I think a little bit tricky. Okay. Because the NSCs and the main contractor have contractually there is a relation with the main contractor, but the timeline is independent of the main contractor because the main contractor could be another 6 months of the work to be done. Because sometimes the employer or want to tidy up the NSC's account. So they issue the penultimate certificate. See here? So the penultimate certificate to the NSCs are different. So you look at the clause 30. So if there is a penalty made to the NSCs, then they'll get off the site already. So it's not to be clause 27. So these are the two clauses you have to look into, because clause 27 is related to the NSCs. See here, how? There you are, final payment to NSCs. See here? So this is the penultimate certificate to be issued. That is the final payment to the NSCs. But to the main contractor, this is the second last certificate. Once the second last certificate, you got 21 days to come up with your final certificate. See the difference? Because if you say this penultimate is the NSC's one, the NSC's could be 6 months ahead. Then 6 months ahead now, because the contractor, main contractor jobs another few, let's say 6 months to go. Then how can it be within 21 days? So please be careful. This is the important one to the main contractor and to everybody. The CMGD once issued, that means you have to come up with your final certificate within 28 days. Okay, so even though there is no penultimate certificate, so if there is no penultimate, it's independent, because this is discretionary. Penultimate certificate is discretionary. So please make sure you understand this concept on final certificate and when to issue. If there's a penultimate certificate, it's 21 days after the penultimate certificate. If there is no penultimate certificate, it will be 28 days, within 28 days of CMGD. That is the situation where it's perfect. There is no dispute. If there's a dispute, so there could be holding up a lot of the tidying up of the paperwork. Okay. Yeah. Under normal situation, the issue is mandatory. See the word here, normal situation. The word is normal situation. It means no problem. Okay. So if you don't issue within the time frame, employer is liable, consultant also liable for not doing their job professionally. Okay. So more often than not, this is the industry's problem. Delay issuing the final certificate until the last possible moment. The reason is very basic. Logically, this should be done. Contractually is wrong. Contractually, you have to follow this, because under your clause 30.14, you issue CMGD, this one you must come out. So what they will do is they won't issue your CMGD. That will be a better method. Okay, so that's why the CMGD is very critical. They try to delay as long as possible rather than the final certificate. I hope you understand the basic approach in the industry. Okay. So 315, there is a condition in relation to your final certificate. Okay. So these are the paperwork that need to be done. First of all, you must get your final account. So that's why I say the final account is the one that can jam up the whole system. If the final account is not finalized, then final certificate, do you think can be tidy up? So this one, the final account is the finalized one. So finalized and no dispute. That's why they say if there's a dispute, the final account cannot finish, then final certificate cannot be so easily tidy up. Okay. And then after that, you get a final account already done, how much the contractor is entitled. Then the arithmetic is very simple already. Less sum previously paid. Okay. So to the contractor, on paper, on your certificate, your last certificate is how much you pay to the contractor and NSAs. That is the total sum. Whether the employer pay or not is a separate matter. If the employer didn't pay, the contractor will take a separate action against the employer. That is separate matter. So in terms of final certificate, this is very simple calculation. A minus B. Then if there is a balance, okay, if there is a balance, the balance can be a positive or negative. If it's a negative, means overpayment. Positive means got balance payment. Okay, so that is how you see whether the paperwork is done correctly or not during the progress of the work. Okay, so if the balance is negative, it's a debt need to be paid by the contractor if the payment is negative. Okay, if the payment is positive, then the employer have to pay the contractor during the period of honoring. So there are two situations. If there is a balance positive, so this one is balance negative. Okay, so this one balance positive. Yeah. So do you see? Huh? So you can see here very clearly stated, architect shall not be obliged to issue final certificate before CMGD. Because you can see the up earlier, CMGD issued, you got 28 days to come out. Okay, if there's no CMGD, how to issue? Okay, yeah, this is the obligation of the architect. And then now we have this clause 13.16. So what is the meaning of this final certificate? Okay, and also any correction that can be made. So the final certificate is to ensure the conclusiveness of the value of the work. See here, conclusiveness of the value of the work, conclusiveness. So the figure is final, okay? So the effect of the final certificate is a conclusive evidence that all necessary in terms of amount or error anything are corrected. This related to amount, the value of the work. So if there's any error, under clause 30.12a and b, or any outstanding claim between the employer and contractor, under 30.11e to g, then this one has to be resolved separately. Okay, so any item occurring on clause 30.11e to g is something independent of this figure, because this could be an arrangement between the employer and the contractor. You go to 31e to g. So you have it here, 3011e to g. So what are the items that we are talking about? So this is the E to G. Okay? Not to be included into the final account. These three items are separate. Now I mentioned these three items. Okay. So LD, set off, clause 30.4, and any interest payable 30.17. So these three items is between the employer and the contractor. So it doesn't affect the calculation anyway. Okay. So if there is fraud, then can be challenged under this ground. Fraud issues related to fraud. So it always can be challenged. So that means that the final account will have to subject to review. So this is the whole purpose of this final account. That's why I say that it's under this category 2. Okay, here, category 2. Final certificate conclusive on certain matters only. Why? You look at the conclusion from your PAM 2018. So the final certificate shall not be conclusive evidence that any works or material. This one is related to quality. Okay, so this one is related to quality. Quality and workmanship. So these items is not conclusive. It means that the amount is in order. The final account amount is in order, but not the quality of the material work, which need to be verified by future tests. Because sometimes the problem will surface even after the defect liability period. Okay, so this is usually belong to latent defects. Items. Okay, because latent defect item latent defects item, it only can surface within the project time and also after the end of the defects liability period. But as usual, latent defects, how long going to last? Under the contract, the contractor's liability on this item is reflected in the so-called Limitation Act 1953. So please understand your Limitation Act 1953. It's going to be 6 years for the usual contract and 12 years for the special contract. Because the latents can appear within 6 years or within 12 years after the project is handed over. Okay, so can you see this is a very long type of liability on the part of the contractor. Okay, so these are important points for you to take back today. So submission to contractor. So as the timeline above stated, so the consultant need to be followed. Okay. So once they have done up already, is the account that they tidy up first. The account to tidy up first before the final certificate. Once the account is agreed, then the final account issued. So you don't issue two together, no way. It's always the account tidy up, CMGD tidy up, then final certificate will be issued. So it is for the contractor to agree on this piece of paper. That is the amount, whether any dispute or not. Not only the contractor, it's for the employer also, not to look through, but more often than not, the employer will trust the consultant's computation for their agreement. Contractor and the employer, more often than not, is the contractor. So once they have done up the figure, the duty of the contract administrator is already completed. It's up to the employer or the contractor to agree or disagree. If they have any objection, contractor have any objection, then this one, you have to get it resolved. Type 1. Okay. That is under the contract, or go to the court to get it resolved. So these are the two methods. If you disagree, then more often than not, if there is a under the contract, there is a channel that is arbitration. If not, then at least your common law rights is always there. Okay, so you will go to the court for the determination of this figure. Architect cannot do anything more because the contract administrator, once they issue the final certificate, their authority on that particular one extinguished. So this is what the final certificate is all about. Okay, so we are going on to the next area, that is your determination under your item. So section 1.18. So what is determination? Okay, so determination, there are two sectors to look into under the contract by the employer. Determination, the clause 25 and the related clauses, sub-clauses is what you need to do. So the moment that you understand the procedures and the issues allowing the employer to determine, so this is the contractual determination. Okay, in your other lectures, you'll find that you keep on hearing me. The contractor or the employer got other ways to determine under the common law. So now we focus on the contractual. Contractual is guided by your clause 25 for the employer to determine the service of the contractor. And clause 26. Clause 26 is for the contractor to determine the employer or to determine the project. Okay, so that is under the clause 26 here. Okay, for the contractor is clause 26 to take action on how to determine. So please remember the action to be taken by the contractor and the employer on these two clauses. 25 is the employer, 26 and related subclauses is the contractor's right, and the process and the procedures how to get it tidy up. So if you understand the employer's way of getting it determined, which is a little bit more complicated because it's a two-step process. Okay, we are going to do that on the employer first. It's a two-step process, and then we will cover the contractor, which I can go quickly already because it's a single-step process. It's exactly the same as the employer, but the situation on the grounds for determination are different from the employer, that's all. The other procedures and everything are quite similar. So once you can understand the determination by the employer, you should be able to understand by the contractor very, very easily. Okay, so I go a little bit slow on the employer side because the steps are more complicated. It involves the architect. So for contractor, there is nothing on architect because architect is representing the employer. So in employer determination, it's a two-step process. And architect must start first. And what are the conditions to be complied? Okay. So now we go to determination by the employer. So these are the sub-clauses related to determination. So 25.1 is one of the important triggers, default by the contractor. So under 25.1, so there are few issues allowing the employer to here is the service. The word here is service of the contractor. So there is a difference between so-called common law determination. Okay, so this is a contractual one. You only stop the service of the contractor. Contractor can go home already. Other contractor can continue or any other thing. Okay, it's the service of the contractor comes to an end. Then there are a few issues. Now the issues after we go and see that under this A to F. So these are the issues allowing the employer to determine So you see under this, allowing the employer to determine. Then we go to one by one. So the determination is not easily done. Please remember, we go to the details on when it can be done. Just cannot simply, oh, what it happened once, only you can trigger. No, there must be a process, a steps that is happening more often, then only you can trigger. So please don't simply invoke the determination clause so easily. There are certain legal principles that you must understand. Then the next important one is the procedures. 25.2 is the procedures. So this is a two-step procedures. So it must be complied, not two steps. Okay. So this 25.3 is an automatic determination, another extra. So if the contractor is already insolvent, bankrupt already, this one is automatic determination. That means the paperwork is very straightforward. So after the determination, then you can see this is a very pitiful to the contractor. Rights and duties of the employer. Okay. So here you can see the contractor is in a very sad and pitiful state. Everything will be done to the contractor if the determination is a valid one. Then this other paperwork, 25.5 and the 25.6 is the paperwork, how to tidy up the account. Okay, so then you can see here the remedy on the determination is always limited to damages. Damages means money. Anything that the employer want to take action against the contractor is always limited to money. Okay, and limited to the money, it can be within the contract to ask for it, or remedy is not prejudice. It means that apart from this contract, here is equals to the common law right. So that's why it says, in determination, the employer or the contractor got two rights. One of them to be done within the contract proper. If not, then you can go for the common law rights. That means ask the lawyer to tidy up the paperwork. Within the contract, you don't need lawyers to tidy up the paperwork. That is the difference only. Okay. So please remember these are the relevant clause and subclauses that you need to do. So the first thing we're going to look into will be these items, and you need to understand them properly. Okay. So this one procedures I mentioned already. This one is automatic determination. I did mention to you. Now we are repeating the whole process. So this one is for 25.4, 25.8 rights and duties of the parties, but more often than not, it's the rights of the employer and the duties of the contractor on what to do. Okay. Yeah. So clause 25 allowed the employer to determine the employment of the service under the contract. So the terms are important. Determine the service or the employment, service or employment under the contract. Okay. So what will happen if the contractor's service, they are determined? So this is called a contractual ground. So these are under the express contractual provision. That means you need to follow 25.1a to 25.1f. Okay. So another important thing, that is the contractual determination. This is the legal principle. It means that the contract doesn't come to an end. It remains, but in a modified form. The word modified form means that certain of the contractual provision cannot be applied already. That is the meaning of modified form. So your PAM 2018 is still applicable to tidy up the work, because the owner need to make use of the PAM 2018 to continue. If the contractor haven't finished the work, had to get a second contractor to do the work. Okay, and then the second contractor who do the work under the provisions of PAM 2018 will have to make use of the client, the consultants, have to make use of the PAM 2018 under the provisions of PAM 2018 to tidy up the account of the first contractor, that is the one that is determined, plus the account of the second contractor, or even maybe there's a third contractor, okay, for getting up the final account for individual parties. So once you get the final account for contractor A, the first one, let's say B, usually the second one will tidy up. In certain situation, maybe there's another one, C, tidy up. Then only the final account of the first contractor will be known. So unless the new contractor taking over the first contractor's item not finalized, the employer doesn't know the extent of so-called charges to be imposed on the first contractor. So please remember that. So this is the reason here. The contract itself doesn't come to an end because another contractor needs to take over under the same situation and then to administer the project. So that's why I call it in the modified form. So this is the principle under Tanzanian case in Miata, Vita Construction versus Tanzanian Harbor Authority. Okay, so the determination is to relieve the first contractor, to be at the project site. That is the key meaning. Okay, so how to go about it? We go on to the sixth default. Now just now you can see here the sixth default of the first contractor. I use the term to differentiate between other contractor. The first contractor. So under clause 20.51A2F. So now the first thing is fail to commence work. If you are given the letter award already and then you didn't commence work, here it means that where LA already issued. Okay, so LA already issued and yet no progress. Okay, so usually the LA will give reasonable time for mobilization. So you can see a site possession date and commencement date. There is a difference, there is a gap. So we call it the mobilization. And then after giving the contractor reasonable time, the contractor failed to commence the work. So this is a trigger, a very good ground that the employer can use to determine the service of the first contractor. So that means they delay the work without good reason. That is the first contractor. The second one, suspension of work by the contractor. So please be careful. The suspension of the work by the contractor, there are two types of suspension. One of them is the legal suspension. The other one is illegal suspension. This one suspension by the contractor. It means this one is the illegal. Okay. So the legal suspension is related to the payment. You come across under payment. Okay. Under clause 30.7. See here. Clause 30.7. It's a legal suspension. It's one of them here. 30.7. You see here? Suspension of what? Because why legal? Employer didn't pay the contractor. See? But in order for this suspension to be legal, the procedures must be followed. So these are the legal suspension, 30.7 and 30.8. So under the 30.7, you have to follow the procedures. Then only the suspension would be legal. Another one is 30.8. Now this one is the employer didn't engage the architect or the other consultants for the project to continue with the work. So this is the another type of suspension that is legal. If not, then the suspension is illegal. Okay, so this one is a illegal suspension. That means wholly suspending the work. So that means not only partly the project is almost like come to a standstill. Okay, the keyword is without reasonable cause. This is the, if it's illegal, it is with reasonable cause. If it is illegal, it means without reasonable cause. The keyword is wholly. It may be the project is a big structure, only a small part of it is suspended. You cannot use 25(1)(b) to determine the service of the contractor. It must be wholly, the whole project, jam out. Okay, yeah. So sometimes the contractor may have their equipment or other resources at the project site, but it doesn't mean that the work is ongoing. It doesn't mean, okay, the equipment may still be present, but there must be a complete withdrawal of the manpower from site. So see the difference? Equipment can be there because you cannot simply shift it out so easily, but the workers are missing. Manpower are totally missing. This is the criteria for you to invoke 25(1)(b) by the employer. Okay, then same case, cessation of the whole of the work without reasonable cause. All the time is without reasonable cause. Okay, the keyword is suspension without reasonable cause. So this is the example given here. You can change it to 1.8. Okay, what does it mean? So employer cannot determine when he's complying with the architect. So these are the reasonable cause. I just want to show it to you. This one under what clause here? Clause 30.8. So under the clause 30.8, just now I shown here 30.8. Architect consultants is not engaged by the employer to continue with the work. So architect and the consultants not the project site. Nobody supervise the work. So the contractor have no choice but to stop work. We call it suspension of the work. Clear? So the third one is fail to proceed regularly and diligently. So please be careful. Understand the term regularly, diligently. Please, you read the tutorial. Questions? On this. What is the meaning of regularly and diligently? It's not your interpretation or my interpretation. Okay? So this item here is a legal interpretation that is required. So what amounts to regularly and diligently? If you don't proceed, it's not your dictionary definition. It is the legal definition. So what are the things to comply to make sure that the contractor is not working regularly and diligently? You look at this case law will give you some background already. Okay. So now the first thing is there are 3 or 4 items that need to be complied. Okay. So let me go back to this item here. See here, regularly, diligently, under your tutorial 1. So now, this is the meaning here. So this type of issues, you have to take this, how to go about it. So this one is this. I copy here and I bring over here. Okay. So this is something that for you to think about. Okay. The definition of regularly, diligently. So in relation to this here, will give you how to carry the determination. But this is to give you the definition under this case law. So the judge says in order for you to fail this test. So these are the 3 things that you must understand. Contractor did not plan, did not have efficient leader or management, or the tradespeople are not competent. This one is called fail to proceed regularly, diligently. Or another way is here. I break it up into further. So please, the next time, if you want to show that the workers is not working regularly, diligently, not to say that they stop work for a few days or their workforce are missing partly and so on. No, they must comply with this criteria. So number 1, fail to plan their work. That means don't have proper leaders at the project site, don't have proper planning, and then didn't manage their workforce. That means the workforce is there, they didn't manage them properly. They have the carpenter or this thing. Okay, didn't provide material sufficiently, and then do not have competent tradesmen. Now, one these 4 categories are there, or 3 items here are there, because I split it from the 3 to 4 here. It amounts to not working regularly and diligently. Please understand that. So that's why you can see here, I have these topics in the tutorial 1 is to help you understand the other content of the lectures. Okay. Next, fail to comply with architect's instruction. Okay. So architect instruction is under which clause? Architect instruction, it will be your 2.2. Okay. So check and see whether it's right or wrong. Clause 2.2. See here, architect's instruction, AI. So one, this is issued. If it's a valid one, you have to follow. Not valid one, then different. So we are looking at clause 2.2, not the valid instruction, because it's given the architect under this PEM clause 2.2 to issue the instruction, and it's a valid one. There is a persistent, the keyword is persistent, failure or refusal to comply. Okay, so with that, then the architect can determine or invoke this clause. More often than not, the architect will invoke this one first. Okay, clause 6.5. And under clause 6.7. What is the purpose of having 6.5 and 6.7? See here. So these are the instruction under this 6.5 where the contractor didn't comply. Okay, and then after the instruction given ready, contractor failed to comply. See, so with this 6.5 and 6.7, then clause 25 will come in already. Persistent failure to comply with the architect instruction under the clause 2.2 to issue, and then fail to comply. So you can see the interlink. Clause 2.2 gives the architect the power to issue instruction, and then clause 6.5, the instruction is a valid instruction. And then if that didn't follow, then clause 25.1d will be triggered. Okay, so these are the important steps that need to be looked into before you use clause 25.1d. So don't just read 25.1d and then you start already. You must go back to the clause 2.2, 6.5, 6.7, then 25.1d are linked. So this is how you understand contractual provisions, and not just read one then start your storytelling. You need to link it up to other clause or sub clauses. So I hope you understand this key important point. Okay, so there must be persistent neglect. The keyword is persistent, not once or twice, many times. Okay, so then it affect the work. Okay, so once it is done, then the paperwork can proceed already. The paperwork you have to follow 25.2. And this one, 25.1e is assignment without consent. Now, this is the Alibaba exercise. Okay, assignment or subletting. This one, Alibaba exercise. So that means the contractor get the job already and then sub it out to another party to get it done. By this process, they get some commission without doing any work. See, so assign or subletting without consent means they don't get the consent or the permission from the employer. That's why this one can be determination. Be careful. Labor sub is not under this category. This usually means the total sub it out, not a partial sub. It's a total subcategory. Alibaba exercise is more like a total subcategory. Okay, that means total sub contract to pay to another party. So usually consent is not given, and then fail to comply with the notice from the employer. Then the third one will be is not unreasonable or vexatious. So the employer must be fair also. Okay, so this is the paperwork that need to be done. First of all, give the contractor 14 days, then followed by another 10 days after the expiry of the 14 days. Then only your letter can go out. If you don't have this 14 days and 10 days, the procedure is wrong under this category. Okay, so different category, the paperwork are slightly different. So the architect must understand which clause you invoke, then to follow accordingly. Okay, so labor subcontracting is not under this category. Okay, but please be careful. Assignment of subletting is not a ground under the common law. So that's why I say please differentiate between common law determination and contractual determination. Okay, so contractual determination is provided here, 25.1a to 25.1f. But you use this ground, ask the lawyer to issue a letter. The lawyer who carried out under this one doesn't know the contract well, because common law, you can't use assignment or subletting as a ground, because common law don't recognize assignment or subletting as a ground for determination. Common law only recognize where the so-called non-compliance is very serious, or it goes to the root of the contract. Then only common law can come in. And lastly, abandon the contract. So that means that the contractor missing from the site. So this is a good ground. Abandonment is actually an action that goes to the root of the contract. So you can see here now, abandonment is a ground under the contract, and also abandonment is a ground under the common law. Just like I mentioned, under common law, abandonment, any action goes to the root of the contract, you can determine under the common law and under the contract. So this is a very special situation. A ground under the PAM2018 contract, and also under law. So this is a very special one. We can choose PAM or common law. But to me, why waste money by going to the court and engage lawyer that you charge you a bomb? Then you better do it under the contract. So this one, you got 2. Okay. So after that is done already, you have to look into the procedures under clause 25(2). Okay. So clause 25(2) will tell you the procedures. So there are 2 steps I mentioned to you. 2 steps. Step number 1 is architect notice. That is step number 1. Step number 2, after the architect notice already, then the employer's notice. So you got 2 steps. Architect notice, then expire already, then employer notice. And there are few things to comply. Architect and the employer need to comply with the certain steps to be looked into. Okay? Yeah. So if you have defaulted already on 25(1)(a) to F, then there will be the first notice by the architect before the notice is considered valid. Okay. So now you need to specify the default under 25(1)(a) to F. Which one? Okay. And then you need to post this correctly. So this is a very important step, sir. If the determination under the PAM, how to trigger determination, you look at the notice section. Notice section is at the back here. How to ensure your notice given is correct. You look at the notice section here. See here, notice clause 38. So this notice is your contractual notice. Okay. Any written notice or other document to be given under the contract, under this contract, PAM, can be by hand, it can be ordinary or registered post. So please remember, ordinary mail or registered post. This registered post must be the post office in Malaysia, register it. Or it can be a fax or by electronic transmission. Now, this is the new edition, electronic transmission under your PAM 2018. In PAM 2006 is until 38.1C. D is missing. So D is something new to 2018. You can use your electronic transmissions, for example, email. If it's no problem with your line and so on. So this is the one need to be followed. Okay. So how to deem it is served? Because different notice have different time frame. Okay. So any written notice served already. So if by hand is at the time of the delivery, that means that the notice passed over, that is the day already served. Okay. By mail or registered post after 3 days. So your serving is not operational until 3 days pass. Okay. Transmitted by fax or fax electronic transmission or fax Okay, so this is at the time of the transmission. That means that you see the transmission will say that is good. Okay, if the transmission says NG and no good, then it's not yet. You have to try until it is good. Okay, to show that it is already transferred over, and that transmission date, keep the slip of the transmission as a proof that the other party have received already. And then the 14 days starts. So this is very important. If it's sent by post, is on your date of your letter plus 3 to 4 days. Then only the 14 days you start counting. I hope you are clear. Don't simply says that the moment I send over, you start to count the 14 days, because the notice only operational after the 14 days, the first notice. Okay, then other things that the architect need to follow. Okay, so that is the first notice. Then the second notice will be the employer's notice. So to the architect, specify the default and post it correctly. Same case for the employer, is quite similar. The employer notice must wait until the first notice expire. You cannot simply before that already issue this one. Okay, so if the service is ineffective or invalid, that means the service by the employer is also invalid, because the first one is invalid, the second one is automatically invalid. Okay, so if the first one is valid, then only how to ensure that the second notice by the employer is valid, you have to comply with all these points here. Okay, so to ensure your second notice is valid, first of all, the contractor continue for 14 days or more. Number one. Okay, so repeat it after the expiry. Point number two. Okay, the second notice must be given within 10 days of this happening. This is important. Okay, the second notice must be given within 10 days of such happening. So the 14 days is already over. Then the employer got the right to do on the 15 days until to the 25th days. Clear? Within 10 days of the continuance. Okay? The first 14 days is for the contractor to default. Then the employer got within 10 days. If the employer more than 10 days, the notice for the second one is defective. Are you clear now? So please remember, this timeline are important if you want to determine properly. And then this is another criteria, have to be posted correctly. Okay, the notice have to post correctly, and as usual, shouldn't be under unreasonable ground. Vexatious or unreasonably, it means something that the hidden agenda by the employer. If it can prove by the contractor, then the service of this determination is invalid. Okay, so now what is the effect of the notice? If the employer send the second notice, it means forthwith. The interpretation of the notice is forthwith, means immediately without delay. So on that day the contractor received this notice, is game over. I hope we are clear. Forthwith means immediately. Game over for the contractor. Contractor had to start demobilizing and all these things from the site. Had to inform their subcontractor, the suppliers, don't bring in any more material. Once you bring out no material, you won't get payment from the contractor. You have to deal with the employer already. So this is a very important point that you need to understand. Okay. Yeah. So the first notice, architect notice, must specify the default of the contractor. Repeat here again. Okay. So this clause does not empower the architect to issue notice based on default on his opinion. You must specify the default, not your opinion. Your opinion, you think that the contractor didn't do their work properly, is secondary. You have to tie back to the clause 25.1a to 25.1f. And how to do it? Look at the legal interpretation, not not your own opinion. If you use your own opinion and it's found that to be not correct, then the determination is defective. Okay, so the mode of service is mandatory under this contract. If you see it had to be done by post, by hand, you follow according to which one of them. You choose one because the timeline are going to be different for it to operate. Okay, so now under the PEM 2018, okay, I need to change already. Okay, just now 2016. Okay, there are few modes, the three modes there: register post by hand, and then fax. And deliver of a copy by fax is not sufficient. This one is okay already, and deliver of fax already is sufficient, but not to be taken away. Sorry about that. Okay, so because in the PEM they include one additional cost by this electronic transmission or the fax here. You can see here fax transmission or electronic transmission. So this is why they enforce on this current technology improvement in terms of the transmission. So now if you receive the architect notice, that means the first notice, what can the contractor do to avoid determination? Okay, he can dispute the notice. That means you cannot proceed already, jam already. Okay, or he can remedy the default as shown by the architect. Okay, the last one is game over. He continue the default waiting to be determined. So the contractor got three options. Option 1 and 2, that means contractor don't want to be determinated. Number 3 is already waiting to be determinated. Okay. Now, we stop here for 5 minutes. Okay. So I will continue 10:08. I will continue at 10:08. From, sorry, yeah, 10:08 a.m. So take a break. I will continue at 10:08. Okay, welcome back everyone. So now we proceed. Situation number 1 here. Okay, so dispute notice. This one, number 1, adopted by the contractor. That means dispute. This tie back to number 1. Okay, so challenge your determination. And then number 2, remedy the defect. Choose to remedy the defect. So to remedy the defect, it must a genuine effort, not simply to bring 1 or 2 people, okay, and then consider as continue with the work already. So this is option 1. Option 2, to kill the option or something. Then adopt number 3 is waiting for determination already. Okay, so you continue the default for 14 days. And then after that, the employer, after the expiry of this 14 days, employer will issue another letter and immediately the service of the contractor comes to an end because it's swapped with. So this is how the determination works. Okay. So then the termination employment, you have to give the proper notice already. That notice, as I say, is the letterhead must be from the owner. Clear? So this one, proper notice, the letter must come from the owner. Owner's organization. Okay, and signed by the proper person. So a lot of time, the signature is done by improper person. The keyword here, the letter must be signed, okay, with the proper person under the proper letterhead. So this is very important. The first one is architect letterhead. The second one, it must be the employer's letterhead and signed by the proper person. The first one is to be signed by the name architect. This one is the authorized or the legal person of the organization. You have to look into their form 2449. So to see who are the proper person, you need to check. Form 24 and 49. So this form 2449 will tell you who are the authorized person to sign. Okay. So if you don't do that, you're in trouble. Okay. So if you have to be on the whatever notice need to be served, you follow accordingly. And then after that, 24 to 25.4 and 25.8 apply. That means the tidy up of all the paperwork will apply. So this is under 25.4, 25.8. Okay. So the thing is, as usual, every time the employer and the architect must act fairly, okay, reasonably and fairly. Okay, unreasonable means that there's a hidden agenda. Okay, so this is something unreasonable, something accidental or purely incidental. Okay, or taking advantage of the other side. Other party is taking advantage of the other side from the business point of view. So this is classified as unreasonable type of action by the employer or the architect. Okay, so we're talking about sharp practice, something equals to the illegal practice already. Okay, So similarly, you define ulterior motive, vexatiously. So these are the definition for unreasonably and vexatiously. Okay. So this is a very serious one, determination. Okay. So you have to follow strictly of the clause must be followed. The keyword is must be followed. Okay. If not, wrongful determination, the contractor can use this ground to show that the employer repudiate or breach of the contract. So this is important. The contractor can reverse and bite back the employer by saying that you don't do this thing properly. Okay, and this is a good ground for the contractor to determine themselves. See, instead of the employer determine the contractor now because of your illegal or wrongful action, it's a good ground for the contractor to determine the service under clause 26. So you can see here the whole determination exercise is very, very interesting. So clause 25.3 already mentioned to you is automatic. Okay. So how to show automatic? Yeah. So this under this situation, under the Bankruptcy Act or under the Composition Arrangement or the Companies Act 1965. So these are the two acts is applicable to show that the company is already going to be bankrupt. Okay. Then now rights and duties after determination. These are the various items you need to remember. 25 to 28. So I keep on mentioning to you, it's very sad to the contractor, the first contractor. Do you know why? So here will tell you that contractor to vacate the site upon determination already chased out already. Okay, that's the first thing. Okay, if you want to fight, you fight under the dispute resolution available. In this case, it's clause 37. Okay, it's clause 37. The arbitration clause. Okay. After that, employer got the right to get another contractor to carry out. See here, this I says, this another contractor or new contractor to carry out work, their balance work amount could be much higher than your balance contract amount. So can you imagine if the amount is higher than your balance work to be carried out, the additional cost incurred to pay the new contractor will be charged to the first contractor. Please remember that. That's why it says a very sad situation coming in already. This sad situation number 1, and this one is your vacate the site, is your number 2. Okay, 1, 2 already. Okay. Then employer and the new contractor are given the right to enter the project site. So this is the rights given to the new contractor. Okay, not only the it's the new contractor are given the right, employing the new contractor to continue the work. Okay, so on top of that, all the material at the project site, the employer got the option to buy or not to buy. Okay, so the employer got the right to buy or not to buy the material and the goods that is belonging to the first contractor at the project site. Okay. Next, all temporary building tools that is not required by the owner or the new contractor, the first contractor need to take it out. Okay. So it allows the employer and the new contractor, persons employed by him means a new contractor, to use all this temporary material and everything if they want. If they don't want, you have to take it out. Okay. So the provision can only extend to goods belongs to the contractor in law. So that means the goods or equipment that are legally belongs to the first contractor. Okay, if it belongs to the third party can take it out. That is the meaning. So this is the case law to tell you the interpretation on what other things can be done and what things cannot be done. Clear? So now, 25.4b, to assign the benefits to the employer and any benefits or the contract that the first contractor have formalized. So what you're trying to say here is this. The employer or the new contractor got the option to continue with the contracts for the supply and material that is already confirmed by the first contractor to continue or not to continue. It's up to the employer and the new contractor to think about it. Okay, if they want this to continue, then they will take over the contract. If they don't want, then the first contractor have to cut off the contract with the supplier of the goods and material. See here, remove the contractor to remove any works, temporary building I mentioned to you that is not required by the owner or the new contractor. Okay, so the architect will issue a letter to the first contractor. If you don't remove it, the employer got the right to sell all these things and park this amount as a credit to the project on behalf of the first contractor. Okay, employer got the power to sell the things if the contractor failed to comply within the reasonable time, and that money after they sell it off, the legal item belong to the first contractor. This item the QS will capture as a plus the disposal of the equipment or material balance at the project site that is not needed by the contractor, the new contractor or the owner. Okay, it must be the property in law, contractor's property. If not, you can't. If it's a third party one, the owner cannot sell this. It's not correct. Okay, yeah. So the employer is exempted for liability when carry out such exercise. So you can see how terrible this action impact on the first contractor that is determined. So the proceed of all this money will be held as a credit. I mentioned to you just now, no? Because the QS will capture it as a credit for the future final account. Okay. So if the contractor is already insolvent, then the employer will keep it for future accounting purpose. So this is the case here. Winter ex parte Boland. Okay, so that is the case to tell you that how to look into the proceed of all these sales. 25.4D, financial settlement after the determination. This is another set part already. Okay, so employer can claim against the contractor. Number one, financial settlement after the project is determined. This is number one. Employer can claim loss and expense. And number two, suspend any payment to the contractor until the account is completed. So can you imagine the first contractor have to wait until all this exercise is completed to find out the final account for the first contractor, for the second contractor, and see any balance money left. There will be no payment from this point onward. Okay, so relief of the obligation to make payment to the contractor until the works and everything are completed by the second or the third new contractor. This is a very important one. Relief to make any payment to the contractor, the first contractor. Even the certificate already issued and not due yet also jam out. So can you imagine how terrible? Okay. So then there will be records need to be taken. Joint records of the extent of the work completed or partial completed. That's why QS will be very busy with these two exercises, and also the material and goods that are required. So this is for the QS to carry out the account. This is a very important scope of work for the consultants. Okay, so you have to keep all the record properly. If not, the once it goes to arbitration or it's not done properly, you will be in trouble. Okay, so now final account after determination. So all these figure will be tidy up until the second contractor finish the job. Then you know the figure for the first contractor and also for the second contractor. So the final account will be drawn out for the whole of the contract as if the defaulting contractor completed them. So this is trying to say that if you didn't do it, never mind, the second contractor will tidy up. Upon the tidying up, then only the whole computation of the amount for the first contractor, second contractor can be known. And then the owner will see who to apportion the additional cost incur to the party that is creating the problem. Okay, so we owe direct loss and expense payable to the contractor. Before the determination is for the QS to work it out what should be the amount for the first contractor, and then what the amount for the subcontractors, and so on. So this is the first part for the main contractor amount. Okay, and then after that, deduct already paid. So this one you can see what is the balance due to the first contractor. Okay, so if there is a net positive, then you got some money left. If you don't have a net positive, then you have to pay the contractor again. See, so the final account will include all the costs incurred by the owner of the project and charge it to the first contractor. So usually, once this figure is charged, the amount to be paid to the first contractor is going to be negative. Okay, so these are the three important elements for the account to be tidy up. First of all is the expense to complete the balance of the work. Okay. Second one, the professional fee incurred because of the new balance of the work, and also other items or costs incurred to be charged. Okay, so any loss by the employer, and this is the direct loss, need to be computed. All this to be charged to the first contractor. Okay, so you can see these are the three figures to be deducted from the final account of the first contractor. So, and then also without prejudice on the remedies or the rights that the first contractor have. That means you can use the contractual provision or the common law provision to take the money from the first contractor. And even LD to be imposed can be imposed if the second contractor cannot complete on time. So these are the very terrible type of situation. But in order for the LD to be imposed, as usual, the CNC need to be issued accordingly. Okay, so all these the procedure partner need to be complied. So the final settlement, whether go positive or not, after all these things need to be packed in, I can guarantee you it will always in the negative. Okay, so to see whether there is a net positive or not. Okay, more often than not, you won't be seeing any positive amount. Okay, so any balance from the employer to different contractor is a debt. If it is negative, if it's a positive, then the owner will pay the first contractor the balance. This one is final amount is negative. Okay, so it will be a debt. And this one is the final amount after balancing, after minusing or return is positive. Okay, so that's why you get this item. So all this had to be the final settlement is as per this contract provision 25(6) or agreed by the party. Okay, so generally these are the timeline for the QS to tidy up the paperwork and pass it to the first contractor and so on. So this 3 months is not the first determination time frame. Okay, so you need to finalize the cost for every party. The 3 months is for the QS to work out after the job is completed. So the final account shall be for the all costs incurred to complete the work. This is very important. To complete the work means the balance of the work also need to be taken into the consideration. And even the LD and all these things, loss and expense, need to be factored in. So this is the QS job now to tidy up the figure. So if there is no dispute, which is very rare, determination already very hostile. Okay, architect, after the completion of the work, submit the final account to the owner and to all the various contractors, because the contractor will be contractor number 1 and contractor number 2. Okay, so if there is no dispute, it's quite easy. Then everybody agreed. The final account is going to be conclusive. Any balance payment shall be proceed accordingly. So if there's a balance money, then it's either a debt or a payment to the parties involved. Okay, so if the final account exceeds the total payable to the contractor, it shall be a debt to the employer. So either you can get it directly from the first contractor. If not, the employer will recover from the first contractor performance bond. Okay, so this one is no dispute. If there's a dispute, then it's going to be very messy. Okay, if there's a dispute, so one of them must state the disagreement so that the QS got 3 months to relook into the figure. Okay, so within the 3 months of the final account received by the contractor, they may agree or disagree. So if they disagree, they will tell their disagreement and send it back to the architect or QS. So then the architect QS got 3 months from the date of the receipt of the disagreement. Okay, so it's whether to amend the figure or not to amend the figure. It's up to the QS and the architect. Okay, so if after that, then they will send the latest decision, will send it to the contractor and the owner. If any of them not agreeable, then they have to proceed to arbitration under clause 37 within 3 months. So this is how the dispute is exactly that what we saw into the final account. It's exactly the same steps there. Okay, 3 months, 3 months, and so on. Okay, failure to refer to arbitration means agreed already. Now this is typical type of understanding. Okay. Yeah. Any on these three items is a separate entity. Is not to be okay. Under the different procedures under the arbitration. It's not inside the figure, but it's a private figure to be decided by the arbitration, or usually or litigation. Often will go to litigation. Okay. So we have finished the determination process by the employer. Okay. So now we look to the contractor. So it's exactly the same. So you need to look into the defaults where the contractor can determine. So this clause 26 will deal with all the provisions one by one. Okay. So 26.1 will specify the defaults of the employer. 25.1 is the default of the contractor. Okay. Then 26.2 is on the effects of the determination, what the employer must do. Okay. So this is under the determination of the service of the contractor when the employer is in default. Okay. So upon determination, immediate arbitration is available. The word is immediate arbitration. If you're not happy, you can go for immediate arbitration. Okay. So this is under the clause 37.6a to D. Okay. Yep. Also, as usual, arbitration or not, you can go to the court without prejudice to other rights. Other rights means the court. Okay. Other rights here usually the common law. Okay. Then you look into the grounds, like what we done for the employer. Failure to pay on certificate. Please be careful. It's not just one failure. Okay. So in order to be able to determine on this, is repeated many times. So under this clause, the contractor entitled to payment. Okay. If not stated, is 21 days from the architect certificate. So once it's not paid, there is a possibility that the contractor can go for this 26.1a. But before that, you need to ensure that it happens not only once, it can happen few times as a record to show. Then you got this right to determine on failure to pay on certificate. Okay. Employer may be held to have repudiated the contract by his failure to pay when due. So this is a very important principle. Okay. So now it's not every single failure. This is why I'm trying to tell you. Okay. So amounts to repudiatory breach. So it have to be repeated exercise. So apart from that, if you don't want to invoke this one, then you can go for interest charges. So more often than not, the contractor will go for interest charge suspension of work rather than invoking this determination. So the determination must be happening. The failure to pay happening many times. Okay. So you give the rights to other things also. So you can see which one you want to choose. This is the last resort to do it. Okay. It have to be employer is paying outside are frequent, and there are many reminders. This is a good ground. Okay, not once. Employer is paying outside the honoring period, and after many reminders, you're not yet, then very angry already, invoke it. Okay, and the other one is interference with the certificate. So this one goes to show that employer discuss with the architect how much to pay, what to pay. It's wrong. It's interfering with the certificate. This one is by the employer and must show the proof by the. So this one, if you don't have this proof, it's very difficult. Okay. So if you can show, then you can determine under this category. Okay. Contractor determine if employee improperly or fraudulently interfere or influence or obstruct the issue of the certificate by the architect. Okay. Not only payment, but other certificate also. So the certificate is extension of time, CNC, CMGD, everything. These are the things that you can look into. But CMGD already completed already. So no, more often is the extension of time and the interim certificate. So these are the ground. Okay. So this case law will tell you contractor how to obstruct and how difficult it is to prove the employer obstruct. Okay. So this one contractor unsuccessfully. See the word here, unsuccessfully. It is because the proof is not there under Lim Heng Tu. But the concept is this: if you can prove that the employer obstruct, this is a good ground. If you cannot prove, then please don't use this as a determination by the contractor. Okay. So there must be actual meddling and all this to be proven. It's not easy unless you have a spy camera inside the building. Okay. This one, fail to nominate architect or the consultants to continue. So under this category, these other parties not under reasonable time to be nominated. 3, 4, 5, 6 under Article 3, 4, 5, and 6. So you look at Article 3, 4, and 6. Who are the people need to be nominated by the employer properly, quickly? Okay. So Article 3, 4, 5, and 6. So Article 3 will be architect. Article 4, engineer. Article 5, QS. Article 6, specialist consultant. If you don't engage them, if it's required, then you can use it. Then suspension of the work. That means the employer cannot continue the work due to possibly financial ground, whatever ground. Okay. So this one could be a good ground for determination. Okay. So these are the 4 circumstances that must be looked into by the contractor due to the default of the employer or the architect. So these are the 4 circumstances. No, in fact, 3 here. 1, 2, 3. Okay. 3 conditions. Okay. So set up the circumstances, and also these are the 3 conditions must be complied. So below are the 3 conditions and plus the other circumstances before 24(1)(d) can be operational. So these are the 3 situations or conditions to be complied. Okay. So the whole of the work suspended. Okay. So continuous period, more than the continuous period. Okay. So one of the more specified event described below. So these are the 3 conditions plus 4 circumstances. Okay. So these are the 4 circumstances just now mentioned above here. See here, there are 4 circumstances. 4 circumstances plus 3 conditions. So these are the 4 circumstances. Okay, architect instruction. It exceeds the period of delay. Asking for all this information, it exceeds. Okay, and then Contractor also must make so-called application at the correct time. Okay. So another one is an employer undertaken the work not forming part of the contract and delay the whole thing. So these are the 4 circumstances. Due to different clause provision. Okay. So when it is done, contractor can determine. So these are the 4 grounds that the contractor can determine A, B, C, D. But D, there are more sub things to look into. So usually this is the area. Usual ground for by the this could be the usual ground because every time out suspension of the work is happening very rampantly at the project site. Okay. So after that, the procedures to be complied is much simpler already. To the contractor is taking whatever machine equipment out from the site and then tidy up the account and get payment. So not like the employer because you get a new contractor to continue the job. This one, the contractor don't care already. Whether you get a new or not new, it's nothing to do with them anymore. So they want to know the cut-off period, the amount of the work done, and the balance of the work is up to the employer to get it tidy up because I have the valid determination. Okay. Yeah. So there must be notification. The notification by the contractor is very simple. Only one notification. That means the contractor must give a written notice, whatever, to the employer. To give the employer 14 days to decide. First letter, 14 days. After the expiry of the first notice, that means the contractor got another 10 days to do it. If the contractor didn't do it within the next 10 days, the notice is defective. So you got 14 plus 10. But on the employer side to determine the contractor is different. You have 14 days by the architect, then 10 days by the employer. This one is the contractor to do all the duration, 14 days and 10 days, all from the contractor. Okay, so the delivery, the notice must follow the contractual provision. And also as usual, you as a contractor cannot determine under unreasonable or vexatious ground already described above. Okay. So insolvency of the employer, automatic determination, 26.3. Same case, 25.3, automatic determination by the contractor. Okay. So then the rights and duties under 26.4 is much more simpler already. Okay. So under clause 26.7, the contractor as usual got other rights in case the employer didn't pay them. See? So you go to the common law rights. Okay. So you have your common law rights here. If the contractual rights is not effective, they can go for the common law rights. So as usual, license to occupy comes to an end on determination. That means I should surrender back the project already. Okay. So remove all the things from the project side. Okay. So you cannot live indefinitely, required to remove them as soon as possible. Okay. So take all precautions to prevent injury to the people or to the property. So it's much more simplified already. Okay. So once this is done up, then to tidy up the account already. Okay. So how to secure payment for the work done until determination. That is what the contractor is interested. So you have your total value of work carried out until determination. If there's any material, then add in the material. Okay. So important thing is this. On those items that is already paid in the previous certificate, the item belongs to the property of the employer. So be careful. Next time as a QS, when you want to pay material on site, a lot of time, most QS make this mistake because a lot of the material on site have credit terms. If it's on credit terms, it means that the material on site still belongs to the supplier. Please remember that. So if you include that material on site, where the ownership is with the supplier, you are paying material on site illegally, because upon payment, the property of the material still belongs to the supplier, because as long as no payment from the contractor to the supplier, the title of the goods and material still belongs to the supplier. Are you clear? So please, next time, don't simply value material on site and put it into the certificate. If there is such a problem happening, then it is the QS negligent or the architect's negligent. Okay, please remember. So how to protect yourself under this item? For your material on site certification, please ensure the contractor show you the invoice plus the payment receipt. Okay, so how much they ask for the material or goods to be supplied plus payment receipt. If there is no official payment, you include it, is at your own risk. So please remember that. This one is not in your text. You better think about it. Most of the QS have this mistake at the project site. Plus any direct loss expense to be claimed. The contractor will pack it in. Okay. So these are not completed work. This is hard time for the QS to evaluate. How many percent of the BQ rates to be applied? Okay. So, or you value them under the clause 16. Okay. And plus removal cost for the things at the project site will be added by the contractor. So all these are the positive side. And then finally, minus the balance paid, it will be due to the contractor. Okay. So as usual, clause 26.5 is on the cutoff point. Need to be recorded properly. Usually now you got your video and photographs. Okay. So it will be done within 28 days of the joint inspection to make sure that everybody is aware on the cutoff point. Okay. And also the material and goods that is delivered and paid. Okay. So once this is done up, it's easy already. Finalization of account. As usual, if there is no dispute, whatever figure produced by the QS architect, then it will be considered as so-called final. Okay. So if the figure there is a balance to the contractor, then the employer will pay to the contractor. If it is a negative, then exceed the total amount payable, then it will become a debt. Either you get it from the contractor or you deduct it from the performance bond. Okay. So if there is no dispute within 3 months, it shall be deemed to be agreed by every party, conclusive. Okay. So now if there's a dispute, it's the same again. If there's a dispute, employer dispute at this time, because this now is the contractor. Okay. Must give written notice to tell what are the things that are dispute within 3 months. Okay. So after that, So now this figure is produced by the QS and architect. Okay. So now we better change slightly here. Okay. Employer dispute. So okay. Amend or not to amend. Okay. In the event that further disagree, then they have to refer to arbitration. So within 3 months of the latest decision. Failure to refer to arbitration, it means they are agreeable already. So these are the steps that you have to look into. Similarly, for the NSCs, the procedure is the same between the contractor, main contractor, and the NSCs. Because with the NSCs is always NSCs determine the service if they got valid ground. Okay, this by NSCs, and then the other one is by the contractor to determine the service of the NSCs. So this one is the NSCs got the valid ground here. Means valid determination by the NSCs. It's between the NSCs and the main contractor. So these are the clause applicable: 27.8, 27.11, 27.12. Okay. So these are the 27.8 will tell you the conditions. So you have to go through what are the condition precedent. Like just now we have all the various items, but this one is between the main contractor and the NSCs. So if it is effectively determined, then what would happen? That means the employer must come in to get a new NSCs to do the job. And then the contractor have to solve the problem between the additional cost incurred. Okay. So if it's a valid determination, then the contractor have to pay new sub NSCs that are coming in. So the employer will have to pay the new NSCs additional payment plus time, additional time to be given to the new to the contractor to complete the work. Okay, granted. Not only additional pay, that means that the old contract sum for the NSCs, it could be, let's say, 10 million, but after that, revised.
Sir, your mic is mute.
Jam, sorry, sorry about that. So you can see here that not only the determination by the main contractor for the NSCs is successfully done, but you have to give them extra time also and loss and expense. Under your clause 27.12, this one is the contractor's fault. So just now the determination validly to be determined by the main contractor. Now this one is main contractor's fault. Okay. Due to the main contractor's fault, then the NSCs can determine themselves, and then additional costs incur main contractor had to absorb. Just now is valid determination, additional cost, and have because the moment you can engage a new NSCs in, it's usually more costly. Okay, so this one is NSCs determine themselves. That means due to the main contractor's fault, architect still had to renominate. No choice, because you need the NSCs to carry out the specialist job. Okay, yeah. So this one is if the old contract sum, let's say, NSC sum is 10 million, and now this one is 11 million, the new NSCs to work up the whole figure, the balance work, plus the old one is 11 million. That additional 1 million, who pays it? It is the contractor to pay it. See here, no additional cost incurred to the employer. I hope you need to understand this concept. Huh? If the NSCs is correctly determine their service because of the main contractor's fault, additional money is from the contractor to get the things done. Okay, so all this additional figure is to be borne by the main contractor. If the new NSCs incur additional cost to complete the subcontract work, the employer incur additional cost in renomination and loss suffered, the contractor must bear. I hope you understand this. So that is a valid determination by the NSCs. Okay. Then the main contractor do not have the extension of time. You don't be getting the extension of time because it's the main contractor's fault. Okay. Yeah. Unless you establish, the contractor can establish is valid. Now then the valid one, the top discussion takes over. Okay. So if it's valid, then the extension of time and money, you are payable. Okay. So if the determination becomes invalid, then the employer will have to take over all the additional costs. Okay. So how to get it invalid? You have to go for arbitration or litigation. I believe most of the time you have to be under the litigation. An example, Pembiran LCL versus SK Styrofoam. So if that's the case, then clause 2711 will apply. That means the valid determination will apply. 2711, isn't it? No? Valid determination. Okay. It's a valid determination will apply. Okay. So with that, we come and end to our topic 118, that is determination exercise. Okay. So thanks everyone. So if you have any query, as I say, you can always ask me during the tutorial session. Okay. Let me look at how many of them are present. So, yeah. Okay, I think 1 or 2 are absent. Okay. So with that, I will stop the recording. So for those